Today, I'm joined by Eugene Rome, who is an expert at dealing with high risk holds, reserves, and things of that nature, where we're seeing a lot of merchants taken advantage of, where money is being held by their processor in a way that's either not legal or in a way that's just not appropriate. And so I'm really excited to dive into this topic today in this short video. Eugene is going to provide you with all the information that you need to understand how to handle these situations and understand them a little bit better. But then ultimately, of course, how to reach out to his firm and work with them to help resolve these situations and hopefully get some of that money back. What is a high risk hold? What is a high risk reserve? What are these topics for those that may not be familiar?
High risk hold would be, it could be just about anything. It could be simply a bank or a processor calling you and saying, look, we've looked at your activity and we think that we need to hold a little bit more of your money rather than releasing it all, because we feel insecure about where we stand in the unlikely event that you disappear or all of your activity ends up as chargebacks and there's not enough money accessible to us to satisfy our liability. Because ultimately, you understand, and I'm sure the viewers do too, that the ISO and the acquirers are ultimately on the hook once chargebacks and returns start happening. A reserve, it comes, in my experience, in two forms. One's a static reserve, and that oftentimes is something that's pre-negotiated before you start processing with a company, or whether it's a processor or if you're direct with a bank. The more likely scenario and the more common one that we see is the rolling reserve. And the rolling reserve is when a stipulated percentage of the monthly transactional activity is held back by the processor and the bank to offset any chargebacks or risk factors that come down the line.
We're talking about high risk merchant accounts. Part of that risk, of course, you can have other types of risk, maybe reputational or that sort of thing. But in this case, we're talking about financial risk. For an ISO or an acquirer, we're worried that we're taking it on a high risk account where there could be really significant chargebacks and some kind of financial loss. So we want some money in the bank that we can pull against to protect us. So we have this idea of either holding funds or doing a reserve. In your experience, what are some scenarios that seem reasonable? So for those, whether it's an agent or a merchant that's maybe new to this process, what's a reasonable policy around holds and reserves in your opinion?
A lot of this is a function of the written agreement by and between the
Right.
merchant and the bank or the processor. So if the agreement says that we will take 10% of your transactional volume and we'll put it into a reserve account, and this part's critical. The reserve account has to be at the bank. It cannot be held by the ISO. It'll be there for an appreciable risk period. Now, the risk period can be a function of what's stated in the contract or the card brand rules. Typically, the contract will provide for something in the range of 4 to 6 months. Under the Visa and MasterCard rules, a card holder has 120 days to initiate a chargeback. So to me, holding funds in a rolling reserve for longer than 4 months, 5 months, to me, that seems less than reasonable because the risk period would have expired. If you're saying something to the extent of, look, pay now, and a year from now, we're going to send you a product.
Right.
Well, in that situation, then the merchant, or rather the customer, will only find out that the product is non-conforming or fraudulent or defective a year from the time of the transaction. So that's a unique situation where a year-long hold period might be reasonable.
Right.
But in a typical situation where you swipe the card and the product comes to you within 5 business days, I think
Hmm.
the card brand rules should be the guiding post for how long funds are held in a rolling reserve.
What are some scenarios where it's like, hey, this is a major red flag. There might be some litigation involved here.
There's a lot of risk. We are exposed to fines by Visa and MasterCard, at which point we as lawyers always say, well, show us some proof. And that gets a little granular because some of those notices may be confidential. Of course, a lot of times they simply don't exist.
Right.
There's always claims of FTC investigations, DOJ investigations. Now, early termination fees, for the viewers that are new to this, they are basically fees for terminating a contract early. But you have to dissect those fees. So look, I can see a situation where an early termination fee of a couple $100s is perhaps valid because of the amount of work it takes to get a merchant up, to go through the applications, to work with them. And then if the merchant terminates within a couple months rather than the contractual period of 3 years, then perhaps there's something owed to the ISO. But what a lot of very aggressive processors have started doing is assessing early termination fees based upon the unfulfilled remaining portion of the
Mhm.
contractual term. And my
Gotcha.
problem with it is for the following reasons. In the high risk space, and people that are in this space will know this, the typical lifespan of a contract or of a relationship of a mid is 4 to 6 months. And the accounts are priced very aggressively so as to make it worthwhile for the processor to go through the process of boarding the account, servicing it, and then a lot of times it slips. The other problem is this: a lot of times these early termination fees, and that's why lawyers should be involved when presented with these situations, they're simply unconscionable. In other words, simply because a contract provides for them does not mean that a court of law would enforce it. And that analysis is very complicated. You get into all kinds of data points for evaluating whether or not unconscionability applies. Some of them are, well, what if it's not the merchant that terminates? What if it's the processor that terminates? What
Right.
if it's the processor that terminates for no reason whatsoever? A couple $100, that's fine. But when a processor keeps accumulating a large reserve and then afterwards tells you, look, not only am I going to keep several $100,000 that I've accumulated in the rolling reserve, but if you so much as make a peep, I'm going to stick you with a bill for another $1 million. To me, that's highly inappropriate.
What does your firm do when you're approached with a situation like this? Somebody comes in and, hey, my processor held, a $250,000 and they've now kind of arbitrarily canceled my account, let's say, and they've told me that the liquidated damages here is $250,000. They're holding all of my money. What's this kind of process? What are the kinds of things that your firm does to help these merchants in these situations?
We narrow in on the processing history. We actually have an expert that works extensively with our firm, and that individual will analyze all merchant statements to see whether or not the reporting actually accords with the merchant agreement. A lot of times, the terms are so granular and the reporting is so confusing, where unless you are a banking expert, it's just about impossible to figure out whether you've been cheated. After all that's been said and done, we look at all prospects and we look at how to make the claim. We either make a demand informally by letter, or we file suit. When we file suit, sometimes these high risk relationships, they're not simple to unpack. What I mean by that is they're not always direct. An ISO may tell you that, look, we're boarding to this bank, but you look at it and you see that it's all done through some PayFac. A lot of times the PayFac is an illegal PayFac. It's not been registered. So we try and ascertain exactly what happened to the flow of funds. And a lot of times we find that there are undisclosed players that the merchant was never aware of.
Yeah.
And sometimes that player may get into trouble or may lose some money. And as a result, someone in the downline hierarchy will simply tell the merchant, look, something went off, or we'll try and come up with excuses. A big part of the analysis is who do we sue, what the claims are, who is involved, and then when these relationships do become a little more complicated, we look at card brand rules as a basis for figuring out whether the structure was even legal in the beginning. And so those are all the elements, or at least a
Hmm.
sampling of them, that go into the analysis of how a lawsuit is structured and ultimately prosecuted.
Great. So for those who, whether it's a merchant dealing with this situation or it's an ISO or processor that has a merchant they're trying to bring over and they would like to make a referral, how would they reach out to you and your firm to learn more and to get some help?
And well, they can call me. We're at 310-282-0690, or they can email me. My email address is erome@romellp.com. That's EROME at ROMELLP.com.
Awesome. Eugene, thank you so much for your expertise today. I know a lot of people will get some value from this as they're searching online and trying to understand these issues they're running into. So thank you for your time.